Section 33. Members of a company. 1. The subscribers to the documents for the incorporation of a company are members of the company and upon incorporation shall be entered as members in the register of members referred to in Section 35. 2. Any other person who agrees with the company to become a member of the company and whose name is entered in the register of members is a member of the company. 3. A member has the rights, duties and liabilities that are by this Act and where applicable, by the registered constitution of the company conferred and imposed on the members. 4. In the case of a company with shares, each member is a shareholder of the company and shall hold at least one share. 5. A holder of a share is a member of the company. 6. Membership of a company with shares continues until a valid transfer of the shares held by the member is registered by the company. B. The shares are transmitted by operation of law to another person, or forfeited for non-payment of calls, or C. The member of the company dies. 7. Membership of a company limited by guarantee continues until the member dies, or validly retires or is excluded from membership. Section 34. Right of member to attend and vote at a general meeting, 1. Subject to subsection 2, and Section 52. A member has the right to attend a general meeting of the company and to speak and vote on a resolution before the meeting. 2. Despite subsection 1, a registered constitution of a company may provide that a member is not entitled to attend and vote at a general meeting unless the calls or any other sums of money presently payable by that member in respect of shares in the company have been paid. Skip Section 35. Section 36. Inspection of register. 1. Except when the register of members is closed in accordance with Section 37, the register, the index of the names of the members of the company and the index of the names of beneficial owners of the company shall, during business hours, and subject to reasonable restrictions that the company may impose, be open for the inspection of a member without charge, and b. any other person on payment of a reasonable fee prescribed by the company, for each inspection. 2. Not less than 2 hours each day, other than a Saturday, Sunday or a public holiday, shall be allowed for inspection under subsection 1. 3. A member or any other person may require a copy of the register or a part of the register on payment of a fee prescribed by the company. 4. The company shall send the copy so required by a person to that person within a period of 10 days commencing on the day next after the day on which the requirement is received by the company. 5. Where an inspection required under this section is refused, or where a copy required under this section is not sent within the proper period, the company, and every officer of the company that is in default, is liable in respect of each default to pay to the registrar, an administrative penalty of 25 penalty units for each day during which the default continues. 6. In the case of a refusal or default, the court may order the immediate production of the register for inspection or direct that the copies required be sent to the person requiring them. Section 37. Power to close register. A company may close the register of members or that part of the register relating to a class of members for any time or times of not more than a total period of 30 days in each year on giving reasonable notice by a. Advertisement in a daily newspaper of national circulation in which the registered office of the company is situated, and b. Electronic means. Section 38. Rectification of register. 1. A person aggrieved, a member of the company, or the company, may apply to the court for rectification of the register where a. The name of a person is, without sufficient cause, entered in or omitted from the register of members of a company, or b. Default is made in entering on the register any of the particulars which, under Section 35, are required to be entered on the register. 2. Where an application is made under subsection 1, the court may refuse the application or may order rectification of the register and payment by the company of compensation for the loss sustained by the aggrieved party. 3. Where an application is made under subsection 1, the court may decide a question relating to the entitlement of a person who is a party to the application to have the name of that person entered in or omitted from the register, whether the question arises a. Between members or alleged members, or b. Between members or alleged members on the one hand and the company on the other hand, and generally the court may decide a question necessary or expedient to be decided for rectification of the register. 4. A company may, without application to the court, at any time rectify an error or omission in the register of members, but the rectification shall not adversely affect a person unless that person agrees to the rectification made. Skip Section 39. Section 40. Liability of members. 1. Before the winding up of a company, a member of the company with shares is liable to contribute the balance of the amount payable in respect of the shares held by that member in accordance with the terms of the agreement under which the shares were issued, or in accordance with a call validly made by the company. 2. Where contribution has become due and payable in accordance with subsection 1, or where, under the terms of an agreement with the company, a member has undertaken personal liability to make future payments in respect of shares issued to that member, the liability of the member shall continue although the shares held by that member are subsequently transferred or forfeited, but the liability of the member shall cease if and when the company receives payment in full of all the monies in respect of the shares. 3. Subject to subsections 1 and 2. A member or past member is not liable to contribute to the assets of the company except in the event of the company being wound up. 4. In the event of a company being wound up, every present or past member is liable to contribute to the assets of the company an amount sufficient for the payment of the debts and liabilities of the company and for the cost, charges and expenses of the winding up, and for the adjustment of the rights of the members and past members among themselves, but subject to the following qualifications. A. A past member is not liable to contribute if the member has ceased to be a member for a period of not less than 1 year before the commencement of the winding up. B. A past member is not liable to contribute unless it appears to the court that the existing members are unable to satisfy the contributions required to be made by them in pursuance of this section. C. In the case of a company limited by shares, a contribution shall not be required from a member or past member exceeding the amount of money unpaid on the shares in respect of which that member is liable as a present or past member. D. In the case of a company limited by guarantee, a contribution shall not be required from a member or past member exceeding the amount of money undertaken to be contributed by that member to the assets of the company in the event of the company being wound up, or E. A sum of money due from the company to a member or past member, in the character of a member, by way of dividends or otherwise shall not be set off against the amount of money for which that member is liable to contribute in accordance with this section, but that amount of money shall be taken into account for the purposes of final adjustment of the rights of the members and former members amongst themselves. 5. For the purposes of this section, past member includes the estate of a deceased member, and where a person dies after becoming liable as a member or past member, the liability is enforceable against the estate of that member. 6. Except as otherwise provided in this section, a member or past member of a company is not liable as a member or past member for any of the debts and liabilities of the company. Section 41. Companies ceasing to have members. If at any time a company ceases to have a member and it carries on business without at least one member, every person who is a director of the company during the time that it so carries on business is jointly and severally liable for the payment of all the debts and liabilities of the company incurred during that period.